So
No shower.
sounds like we got a good amount of people online too. So I can't keep this thing from falling. All right. Well, welcome. We're excited to start this series of Title Talk Thursday, second Thursday of every month at 11. The Chick-fil-A is on the way, so when it does get here, I'll let y'all take a break real quick and go get it. But I have a sign up sheet. Make sure everybody signs it. For those online, I think Mal was going to circulate one to you guys as well. I think just make sure if you have your license number to put it on there. That's the main thing I need so that we can give you guys your CE credits. So it's going to start the 2025, huh?
People are suffering.
So, so my teaching strategy is kind of like informal. I want this to be like, if you guys have things to say, chime in. I don't want to be a lecturer. I kind of like it to be interactive. So, so yeah, with that, today we're going to talk about CYA. You all know what that stands for?
Cover your eggs.
CYA for realtors. So it might not be as like, I figured we'd start with a more fun, shallow topic today, and then as the series go on, and since we're getting good turnout, we'll start diving into it. I think next time I might do deeds, but I'm always open to taking suggestions. So, but yeah, every class will be for CE credit unless I say otherwise. So, if we decide like, hey, there's something pressing going on, I'd rather talk about that next time, I'm open to something like that too. So, so yeah. With that said, I created this with ChatGPT, so if there's any errors or anything like that, it wasn't my fault, okay? So, how do you CYA as a realtor? I've got 10 points for you guys here today on kind of best practices for realtors to keep you out of trouble, right? Because real estate's hard enough, the last thing that we want to do is get in trouble, lose our license and our livelihood, right? This is our profession. This is what you guys do, and nobody ever wants to be in trouble with DPOR or anything else, right?
Not at all.
So the first, now a lot of these you're gonna be like, wow, thanks, John. Is it here, Tammy? All right, is it here? We good? Why don't you guys go get some Chick-fil-A real quick, and then we'll put that on pause.
Now we gotta go get it.
Before we get real started, I haven't even.
We are not burgundy.
What is it, Merlot? Go through CYA. Number 10, consistent and equal treatment. You're gonna hear me say like, no dud. You're gonna probably think in your head, no dud, John. Like a lot of this is just common sense, right? But it's good to hear. It's good to know why. Some of these are related to statutory codes. Others are just literally best practices, right? So consistent and equal treatment. There's no better way to CYA than to treat everyone in a consistent, equal manner, right? Anything short of that, and you're gonna make defending a fair housing claim pretty difficult. That's the whole basis of the law, right? Is we treat all people, no matter their gender, class, ethnicity, we treat them all the same. And if you treat any clients inconsistently, how does one answer the question as to inconsistent treatment on the basis of something other than a protected class? You're gonna have a really hard time fighting any sort of fair housing claim. It's good to know your protected classes too, at the local level, but not necessarily as long as you subscribe to consistent equal treatment for all. Does anybody know the protected classes in fair housing? I teach a fair housing class, that's 2 hours, so that's a whole other topic. But what are the protected classes?
Race, gender,
Yep.
age.
Uh-huh.
Disability.
Uh-huh.
And
Yep, disability. Yep. Anybody have bonus points for age? What's the starting point?
There's no starting.
Well, 55 and up is like a specific class that they, yeah, we said, so race, color, religion, national origin, a lot of those kind of seem the same, but, sex, familial status, disability, and age. I think we got all those. So good job, extra credit. So that's a whole class in itself. There's a lot to unpack with fair housing, but consistency is key. Just be consistent. And that applies to, I mean, that just makes us more successful people if we're consistent, right? I know Maria's always preaching to you guys about process and doing, you know, trusting the process, right? Just be consistent and especially with this. And we think of fair housing from its historical roots in 1964. That was in response to racial discrimination against racial minorities. You'll see from the language though now, this is expanded and now there's a lot of different protected classes, right? So an Asian woman could be just as discriminated against as a black male, right? This is expanded and now there's a lot of different people that this touches. So it's pretty common sense, but just remain consistent in everything you do, treat people the same, and this won't be an issue, right? So number 9, remain in your sphere of competence. This is not law, this is just best practices, just kind of made up by me, but remain in your sphere of competence. So in real estate, your license entitles you to provide real estate services in a lot of different areas. You guys can do commercial, you can do land, you can do residential, you can do leases, you can do a lot of different things, right? But that doesn't always mean you should, right? As we know, real estate is not a one-size-fits-all approach. It comes in a lot of different shapes and sizes. Going outside of what you are good at, what you specialize in, is risky and it can be dangerous for obvious reasons. Does anybody know what NNN stands for? Triple net in commercial.
Yeah. It's,
You're working on it right now, so I hope so.
no, it's where, triple net means they have to pay their lease and they also have to pay property taxes, utilities and.
Yep, taxes, insurance, and CAM charges are all included in your lease.
What charge?
CAM. What's CAM stand for?
I don't know.
Common area maintenance. Common area maintenance, like split, if there was like a shopping center, they're all responsible for that common area maintenance.
So
So you-
NNN is like a,
Triple net lease,
escrow?
it's a lease.
We don't have that here.
Yeah.
Yeah.
Really?
Commercial. That's
Are
what,
all the commercial leases?
a lot of them.
But it'll say in the description if it is triple net or not.
Yeah. So you see where I'm going with this?
Yeah.
Right? We all stumbled through that, right? So I have a law degree. I can practice a lot of different areas of law. I can be an estate planner, I can do real estate, I can do litigation, I can do medical malpractice, I can do personal injury. Should I do all of those things? No, the days of the general practitioner are pretty much gone. You know, you used to see it, maybe you still see it in the small towns because there's only a couple of lawyers that live there. In my wife's grandma's town, right? It's like one guy and he's the town drunk and he practices everything. I went against him in court in my first case and I wiped the floor with him because he didn't know real estate, you know what I mean? And so, again, the days of that general practice model are gone. Like we have specialties in everything. Part of the reason for that is because of lawyers. So many people have gotten sued, right? Like you don't go to, one doctor is not a brain surgeon, a foot surgeon, a family practice doctor and an OBGYN, right? It doesn't work like that,
That does not.
right? And it's no different for real estate. It really isn't. You guys don't want me to represent you on your divorce. You don't, because we're gonna lose. I don't want to fight hard for you, but we're gonna lose, right? And so remain in your sphere of competence. Literally, the guy that runs this or that started this brokerage literally wrote a book called what? The One Thing, right? Focus on the one thing. I literally hear realtors all the time come to me and be like, hey, I want to get my notary license and do closings. And I literally know a realtor who is an appraiser, appraiser, notary, realtor, and lender. And I'm like, dude, you're never going to be successful because you're a jack of all trades, master of none, right? And so, yeah, I mean, that's just the old cliche that you hear, but it's so true. The more you're in, the less you're going to be good at something, right? So remain in your sphere of competence. That's, yeah, this is driving me crazy. I'll put it right there. All right, any questions on that? Pretty straightforward, right? All right, number 8, only a court decides the fault. This is a big one, and I hear realtors throw this around all the time. Again, this isn't statutory necessarily, more common sense. Not all real estate deals go smoothly, right? Or does anybody disagree with me? It's easy to point fingers, make determinations, which ultimately might be legal in nature. Your clients might also rely on these accusations that you're making, to their detriment. Agents, lenders, settlement companies, and brokers do not decide the default in a contract. We all have our opinions, and some of us, you know, especially as attorneys, we might have a very, you know, we might have a much more calculated approach to it all and understand, like, yes, this would be a very good case. But that doesn't matter, and that doesn't actually determine default. And the only people that do are a judge in the court. That's it. So, for example, in a real estate case, a seller tries to unilaterally void a contract. Did I flip this? Yeah. A seller tries to unilaterally void a contract because the buyer missed their home inspection deadline. This is a real life example, but the attempt to void the void cost the seller dearly when the case went to court because the realtor told them that they were outside the deadline when they in fact weren't. Right? And so these things happen more than you would think. So don't overstep your bounds no matter how strongly you feel. Half of the battle in being a realtor is managing emotions, right? I see a lot of times where the realtors take on those emotions and it seeps into theirs. And I'm feeling all of this, right? And I'm hearing clients and realtors and I get it because a lot of people feel like they've been wrong. Literally was on the phone yesterday with these clients who can't agree on how to split their estate proceeds, right? And I felt like a shrink more than I did a lawyer. I guess that's why they call us counselors, right? But no matter how strongly you feel, and you might even be in the right, be very careful how you advise your clients in these situations when a deal goes south. You're going to hear me say this a bunch in this class, but just surround yourself with a trusted circle. A good attorney, a good lender, a good home inspector, and all the other vendors that you need to be good in this business. And defer to them in areas that might get you in trouble, right? Because you guys might know all the answers to these. My mom's a realtor for 30 plus years. She knows a lot, you know, and anytime I talk, she usually knows these things, right? But that doesn't mean she should be telling her clients these things because she's not licensed. And that's when you get in trouble. You guys have all heard of the unauthorized practice of law. That's a real thing, and it can get a lot of people in trouble, including realtors. So by doing that and telling your client, yes, the other side's in default, technically you're giving them legal advice. But be very careful of that. It's very easy to do. Usually it's pretty cut and dry. They miss a deadline. Usually you know, right? You've been in this business long enough. The contract is pretty black and white in that regard. Then, you know, it's safe to say. But you can point them in that direction, but say like, hey, talk to the attorney, see if I'm missing anything. Or, you know, let's see how we can approach this. Because you advising them and then relying on that and then losing in court, that's going to cost you. So, any questions on that? Cool.
John, what,
Yes.
I guess just because I bump into a lot when people either call me and then I tell them to call right because they don't have to.
Yeah.
Is the whole, like, I hear Rick say a lot, like, your client needs to consult an attorney. Like, we're at that point, right? So like, does that ever end up on your plate?
Yeah.
And then what do you do?
I mean, when I'm part of the
Consult them?
transaction, I'm happy to,
Okay.
you know, consult them. And then
Got it.
usually if it's gonna go to court, we farm it out.
Right,
Because we
okay.
don't have time. We have too much
That's
volume.
cool.
But yeah, and so, but yeah, I mean, deals, it happens, right? And most of the time it ends up like, oh, this is that. And then one attorney draws an email or a letter and it goes away, right? Because usually one side knows if they've talked to an attorney that they're in the wrong. Because I'm not gonna mislead my clients. I'm gonna tell them when, you know, no, this is what the contract says, sorry. Yeah, I know you feel this way, but you're wrong, you know? But yeah, and it happens, and a lot of times these things go away. I mean, how many of you have actually gone to court over a transaction? One.
Wow.
I mean, nobody wants to go through it, because A, we never really know what a judge is gonna decide, because they're the ultimate ones that decide default, right? And as strong as a lawyer, a lot of times you might think you have the strongest case, but you can't guarantee anything. You just can't, because only a judge decides default, and how he interprets that, the case law or the statute might be different than another judge. And so that's again why I say to caution to be very, very careful about that. Yeah.
We just had a situation that went to Rick. And I talked about it in PC today. It is so important, all those little boxes to check. The seller, when they counter offered, did not include the as-is addendum and tried to ratify without that, but because that box as-is addendum was checked, that was considered part of the contract. So be very careful with all those
That's
little,
good.
Technicality.
seemingly little things.
Yeah, it's easy in counters especially, right? Counter
Yeah.
offers. It's easy to just like glance over it or not see an initial or something like that.
Yeah.
Especially, yeah, that's good. Maintain confidentiality. It's number 7. This is breached way more than you guys think. I have a real world example that you'll find probably funny and scary at the same time. But it's probably the most violated statutory duty that real estate agents commit, even though it might be inadvertent. You have to maintain the personal and financial information of your client confidential. Revealing this information can cause real harm to your clients in a real estate deal. So here's an example. Two agents are having lunch, well, right back here. I'm not saying it happened here, but we're just gonna run through the scenario. 2 agents are having lunch, gabbing about their clients. One agent's got these clients that are driving them crazy. We all have those. And, man, these clients are going through a divorce. They're driving me crazy. We'll take any offer at this point. We're desperate. Well, the other agent just so happens to have buyers that are looking exactly for a house that matches the criteria of that listing. What does that buyer's agent have to do? She's got to tell her clients. That's information that's required. And we'll actually go through that in one of the other bullet points. But that's information that she has to disclose to her client because it's pertinent to her representing them, right? So now that agent just costs her clients probably tens of thousands of dollars because they lowballed them and they took the offer. Whether her clients ever found out about that, who knows? But her releasing that information, even though might have seemed innocent and just like friendly gab in the office, cost her clients a lot of money. And if that went to court, she would definitely be able to hunt for that. So, we as lawyers have a confidentiality duty as well. A lot of professions have this, but we especially have one. We can't share anything about our clients that would be to their detriment. There are ways to share information if another party couldn't identify them, but just be very careful. Like the more vague, the better, right? How long does your duty of confidentiality last? Yeah, to the grave. It's not even after your relationship with them is over, you might not have talked to them for 10 years. You still have a duty to them. That goes towards agency law, which is another class I teach, but it's personal and financial information. Okay. It's easy to do. It's the water cooler talk at the office. But the reason that other agent had to disclose it is because it's a material fact to their clients and they have an ethical duty to do that. Hey,
If you've had, so I've had clients where they're like, if they know there's a divorce, they don't want the house, they feel like it's got bad news. Which is crazy, but like,
Offer to say.
At my last house,
so like,
bad.
I have to tell my clients, hey, there was a divorce situation here, or can I just,
does that negatively impact them?
well, they don't want it if it's, you know what I'm saying?
Oh, you're saying like that's a criteria? Well, if they've told you that, I mean, if they've told you that that's important, otherwise I'd say no. But if they've told you that's something that's important to them, then yeah,
They say
maybe.
it, they just.
Would you?
But how often do you know when a sellers are getting divorced? You don't usually know these things.
But so if I know, well, I had a situation.
You might know it once you get under contract because maybe through the closing process, then you find out, oh, these people are saying.
Else. And there was, I had a situation where these people like constantly like, oh, it's kind of that bad. But.
Well, just make sure they do that before they go under contract, because that's not a reason to terminate. Nothing in there says, you can back out due to bad vibes.
I knew people from just the community, so I knew that's what.
I wonder what makes a house have a bad vibe.
Right, that's what they.
Like, is it lighting? What is it?
So John, so all of us have done it. So basically, I have a listing that's getting a little stale, that's in Churchill,
Mhm.
that's buyers, definitely
Mhm.
do it for me. It's stale, so it's been on the market for like 45 days,
Okay.
and I'm definitely, I'm calling people and letting them know, hey,
Motivated.
I have a client, they're extremely motivated.
Sure.
That's the same terms as desperate.
Mm,
If we don't, you know,
I would disagree.
What if
I
you
disagree.
disclose them?
But she also said
Let-
they'll
let-
take any offer. She said
Yeah.
they'll take any offer at this point. They just want to be done with that. That was my whole phrase.
Right.
I don't feel like your clients will just take any offer,
Yeah.
right?
but we are.
But even
able
if
to-
not, they've probably told you, hey, let's push this, right? So you're not doing anything wrong.
So we can say those terms.
Sure, as long as like your clients are on board with this, especially, right? Like if you're trying to drum up business, you're not just taking any deal, but motivated seller, you see that a lot. I don't think there's anything inherently wrong with that.
Well,
I think it could get you into some trouble, but like
Okay.
but I don't, yeah, but just talk to your clients and be like, listen, I'm thinking we put motivated seller. This will start encouraging more offers, but beware, you're gonna get some lowball offers. Because when people see that, investors light up and.
Absolutely,
Yeah.
yeah.
So just be transparent. The more you talk to your clients, and that's another thing we're gonna go over in here. But the more you talk to them, and run these things by them, the less there's anything in the dark, and the less that you're gonna get in trouble. You know what I mean? So, good question. Number 6. Dual agency. I heard a couple groans. Yes, what Maria said. That's my stance on it all. Don't do it. But it presents some potentially awkward spots for realtors, particularly when one of your clients is new. There's different disclosures required if you have 2 existing clients versus 1 existing and 1 new client. But that's more than we need to cover. I'm gonna read to you the disclosure language from the statute in Virginia that you have to provide to your clients when it's dual agency. Following the commencement of dual agency representation, the licensee, that's you guys, fancy way of saying real estate agent, cannot advise either party as to the terms to offer or accept in any offer or counteroffer. However, the licensee may have advised one party as to such terms prior to the commencement. The licensee B cannot advise the buyer client as to the suitability of the property, its condition, and cannot advise either party as to what repairs of the property to make a request. The licensee cannot advise either party in any dispute that arises related to the transaction. The licensee may be acting without knowledge of the client's needs, client's knowledge of the market, or client's capability in dealing with the intricacies of real estate transactions. And either party may engage another licensee at additional cost to represent their respective interests. Y'all get all that? I know I read it fast.
Yeah.
So what can you do?
Nothing.
Figure it out.
You're basically no longer a real estate agent.
Yeah.
You're just pushing paper. You're a clerk, essentially. You can't give any advice.
What I do.
You can't advise the
prior-
suitability of the property. You can't tell them about repair requests. What are you doing?
I do it prior before we're actually under like the contract. Hey, I can't advise you while we're in this. And I always do it with investors. I do it with a really savvy buyer.
Yeah.
I don't do it with someone like a new buyer or someone like that.
Yeah.
That's too risky.
Yeah.
So I have found recently with this new law that's in place,
Uh-huh.
there are buyers that come to open houses. They don't want
Sure.
representation, but they
Sure.
want to put an offer in.
Sure.
So then I take it as an opportunity to just explain to them, I could write
Absolutely.
an offer as an unrepresented buyer, but I make it real clear that I cannot negotiate for them
Mhm.
and I continue to represent the seller. Is
Mhm.
that?
That's fine.
Is that too-
Unrepresented. You're not representing both parties.
Okay.
This is what I recommend is to do you're allowed to draft a contract still with the terms that they presented because they're unrepresented. And I think we're gonna see a lot more of this
Yeah.
now. I think you already are as,
But it feels very much. like
It feels weird, right?
slippery slope of dual agency, but I'm like trying to.
it's all about disclosures. You're disclosing to them in writing that you do not represent them. That is the key.
But you can write the contract.
Absolutely, yeah. Yeah.
Just get that.
If they present the terms to you, they have no other way of usually getting it to you. No, I can't tell you that.
Right.
I don't represent you. You're trying to save money. But it's gonna bite you in the butt.
And I'm gonna tell them, you write your term in an email so that you have documentation that it came from them and that's what you presented.
Yeah.
So then the second part of this
Mhm.
tricky part
is this particular person has a house to sell and has
Mm-hmm.
to represent them to
Mhm.
sell their house, but yet they want to be unrepresented to put an offer on a house unlisted.
That's okay.
So that's made it very like,
Mm-hmm.
so,
It's
so
weird,
do you
'cause you-
try to separate that as much as you possible?
Yeah, absolutely. So we're talking about double jeopardy where you're literally representing both sides. And I just strongly advise against that. Because as you just saw, you can't negotiate, you can't advise, you can't tell us the condition of the property and repair request, anything. You can't do anything when you have both sides. Unrepresented, that's a whole nother story, and that's what I recommend. Because you're gonna see the situation, it's gonna happen, right? And so how you handle it is you literally just disclose to them as per law, so that they don't real think that you are representing them. But then you could draft up the contract and you can do what you have to, and you're completely okay.
But you can't charge them anything to draft the contract, right?
So there are, yeah, I probably wouldn't, just because you start getting into the double jeopardy, but technically, you can even take on like limited representation, but then again, now you're representing both sides, so I strongly,
Taking the fee
Yeah.
implies that you're working for them.
which you can limit the scope of your work, but I just be very careful with that. Because you can, it's called limited representation.
You charge your seller
Yeah, I was ready to say that, 'cause that's what I usually do.
X%.
Yeah, and so,
Doesn't represent you, you're doing all the work, so.
yeah, and so in the old days, right, before this new settlement came, this was the way I told you, because the main reason people do double, representing both sides is because they wanted that full 6%. But you could still get it in the old days by doing an underrepresented buyer, because the agreement said 6%, if there's no other agent, then you got it all, right? Well, nowadays, things are a little bit different on that end, but there's still, everything's negotiable now after the settlement, right?
And this
Everything.
agreement says that if you have an unrepresented.
Yep. So it's still very, very pertinent. It's just changed a little bit, right? And so you could still get your big commission without having to sacrifice and put yourself in a really awkward situation. Yeah.
This is unrelated to dual agency, but it just popped up when you said commission. So are we able to, I guess, change commissions based on the, I guess, financial ability of our client? Because I have clients at different price points. I have some at $1 million. I have
Talking about
some
the
at
listing side or the buyer side?
the buyer side. So basically $1,500,000, and then they can vary like 250. Am I able to say, you know what, I'm gonna charge you just 1%?
I mean, realtors can always give credits back, right?
So I can do that without like getting like in trouble, because a lot of my business is referral
You're
based.
saying like on your buyer
Mhm.
agreement, like when I have 2.5, I might have.
Absolutely.
Oh,
Will it come back on me?
On a case by case basis, you're saying?
Will it come back on me? Can I get
Well,
sued?
no, because I mean,
Negotiable.
everything's negotiable now.
But what if they talk to each other and say, hey, I'm gonna charge me?
Well, here's the
Because
thing.
I get a lot of referral
But-
fees.
One would say,
They may have negotiated, like you said,
Yeah.
everything is negotiable. So that's always where you have to back in. Your buyer A may have negotiated at 3, and then buyer C may have negotiated at 1.
it's, if they approve though, that you're just offering this straight up, they could say like, well, why is she treating me differently?
That's what I'm saying. Well.
But again, that'd be a pretty hard case to make. Because again, with commissions, everything is negotiable.
Everything's.
So you'd say like, we negotiated, like, there was a fair negotiation. Why are you mad at me? Like, like,
But it's.
this was
okay.
negotiable.
But it's.
We
okay.
entered into a contract that you could have asked me for less, and I could have said yes, I could have said no.
That's true.
Everything's negotiable. Every situation is different too, right?
The 250,000, my commission will be this, 200, the house is 250 to 600.
Exactly. That's what I'm doing.
Like a tier.
That's like a
Yeah,
mix.
That's what I'm doing, the tier structure.
Yeah.
I can't.
I don't wanna give a blanket answer on that. I feel like I'd have to do a little bit of research on that before
That's what I'm doing.
It's interesting, but I mean,
Well,
worst case scenario, it'd almost be easier to give a credit after you've entered it, like under contract, and you can give a credit at closing. Something like that. Might be easier, or you can always amend an agreement later, right? Maybe enter everything into 3, and then, circumstances arise where they're short on closing costs, something like that. Now you look like the hero, because you chipped in $3,000 for closing,
That's true.
right? And now they're gonna use you for life and refer you to all their friends,
Mhm.
they're, go ahead.
Kind of late, does that look like our income then?
How do you guys report that, Maria, when you guys do credits for a broker level? The big credit, does it still count as a full commission on a,
No,
no,
it comes off your 1099.
Yeah, that's what I
goes
thought.
on As a credit,
Yeah.
the buyer. And the lender has to go approve it. Yeah, it comes off, yeah, you don't pay taxes on it, 'cause you're not receiving it.
plus if you did, that would be an easy write-off, because you just show that paperwork.
Yeah.
Yeah.
Mhm.
Not a tax professional, so. Yeah.
Consult your accountant.
Yeah,
Right. So two.
Sure.
So first, doesn't that, if you consistently change or negotiate a different fee, isn't that inconsistent treatment?
depends on how you go about it. Yeah,
That would not be good.
depends on how you go about it, but
And the
it could be.
second is, any words of wisdom, or cautions to teams?
Teams?
Teams, sometimes well, you're on the same team, even sometimes they think you're in the same office, so we all talk,
Yeah.
really, yeah.
What in regards to that, I guess? What do you mean when you say?
I've had clients who think just because I'm working with another Keller Williams agent, it's like it's dual, are they really?
Oh.
And even more so when you're on a team.
We have disclosures for that.
That's a definite.
Yeah, you have disclosures for that, right? So the clients are fully aware,
Yeah,
right? And obviously you guys are still representing different clients.
Yeah.
Right? So you still need to be doing the best by the client, even if you're on the same team or whatever you might be. Right? And so a little different than dual agency, but it could bleed into it in some capacity.
Usually can't get involved at that point.
Yeah.
Right, like that's when he's like, that's when it does, sometimes I feel like it somewhat hurts the client, unfortunately.
Designated.
Well, yeah, it's when you've got two agents under our brokerage. And, it just is what it is, it happens, and something happens, and Rick's like, I'm so sorry, I can't advise either one of your clients, your client is going to have to seek legal representation.
Because remember, the broker represents the client, not you guys technically. You're an agent of the broker. So it's a little bit complicated,
So
but,
that's when it
So as
gets
the agent.
but you guys are disclosing anytime there is a designated.
What if
So
the
the
seller?
clients are aware.
What if it's designated agency by Keller Williams, but then you also represent Asbestos both sides? Can you advise?
That's different. That's different. If in that situation, when you're using Vesta, where it is in the role of like a title company, right? And so if push comes to shove and all of a sudden they're disagreeing on things, I can give my opinion on what I think, but then like, once it goes to like a litigation matter, that's when I'm referring it out. You see what I'm saying? So, it's why a lot of like the law firms don't like to do both sides, but you still see them do it too. But again, everything's disclosed. Whereas when we take it on as Vesta, technically we're not doing it in a law firm capacity. So we're able to do it that way because we're representing the transaction that way. But then you have attorneys on staff. Because I'm technically employed by our law firm, not Vesta, believe it or not. So it's just how we've done things. And it's how we're able to still give advice and stuff and everything. Yeah, so yeah.
Back to Peggy's situation. So if she's working on the house, represents her seller.
Yep.
Someone comes in and say they want to
Sure.
be represented.
Yep.
But they need to sell their house first, so now she's gonna list that house.
Okay,
And that's contingent.
Okay.
I mean, can you separate those two? Can you be
Um,
on one transaction, but
yeah, I mean, it's a separate transaction. Technically, like, you would say they're linked together, but the only real thing is it's just contingent, and if she drafted that for them as an unrepresented buyer, I don't see anything wrong with that. That's a whole separate issue, like, I know it's linked in that fact that it has to sell, but that's it, right? And so.
definitely know their.
You can't disclose to your current sellers how much you're selling that for or anything like that, which they could easily pull that up on the internet, or how much you're under contract for, because that's confidential, but yeah, otherwise I don't see an issue with that. That's a good question. Confidentiality is a hot topic, huh?
Yeah.
Yes, it is.
Everything has to go perfectly with dual agency. Like if it doesn't, you're gonna come out looking terrible. And you probably lost both clients' business for the rest of your life. So just be very, very careful if you've got to do it, but I highly recommend it. Just don't do it. Sounds like the broker level, they're recommending the same thing. I know some brokerages that literally don't even let
Yeah, they
you.
don't allow it.
Yeah. I know some
Where's
brokers
the
don't even allow
most, claims against
Oh,
your license?
it. Easily. I mean, as you see, you can't do anything. So everybody's mad at you.
Everybody
end of it.
thinks you gave.
Yeah,
Well, and now that we have an unrepresented buyer contract or option, it's the same thing as doing dual agency, but it's better for everyone involved, like, why not opt for that?
Yeah.
You're still, hey, buyer, you're still not represented, but at least the seller is.
You still get your big
It's,
commission.
it's the same thing. You know?
Yep.
Doesn't make sense to do it.
Don't enter into one half-heartedly, really give it thought if you're gonna do it. But be very, very careful. Number 5. Listing agent disclosures. Looks like the top of the screen got cut off, but that's okay. Listing agent disclosure. So this is statutory, it's Virginia law. Everybody knows that a listing agent has an extra duty that buyer's agents don't, right? Hopefully. And that's comes straight from Virginia law. So when you're a listing agent, you have to disclose any material, adverse facts concerning the physical condition of the property of which you have actual knowledge, straight out of Virginia law, okay? So it's a 5-prong test. In law school, they have you break down statutes into prongs, so it's easier to remember. So I broke it down into 5 prongs, okay? And we'll run through it. So is it material? What does material mean?
But like.
That's
if
another
it's
definition for it, but not this.
like important or like
Relevant
relevant, yeah.
would be the best word, but important, yep, important, relevant, okay? That's a little bit subjective, right? But I think overall, we all know what matters and what doesn't in a transaction, right? Is it adverse? What does adverse mean? Yeah, bad, AKA it's bad. Is it a fact or something? Well, nowadays, people like to throw that word around a lot, that something's a fact, right? But a fact, the definition of a fact is something objectively verifiable, right? Like when I think of facts, I think of science. If the same experiment's done 10 times, that result is the same, right? That's a fact. You can't dispute that.
PW is the best brokerage. Fact. I've done my research.
Yes. Right? And so it's objectively verifiable. Number 4, the physical condition of the properties. So this is just the 4 corners of the property, nothing outside of it. You're not talking about the neighbors. You're not talking about the street or anything else. We're talking about the physical condition of the property. And 5, probably the most important thing for you guys to realize is you must have actual knowledge. So there's a lot of different types of knowledge in law. There's actual, which means you actually knew about it. Someone can prove you actually were told something. There's constructive, which means you should have known. And then there's implied, which means like you knew, even if you're saying you didn't, like anybody else would have known. So there's like 3 types of knowledge in law, okay? The statute was very generous and said only actual knowledge. So they could be like, even if your client made all these insinuations or, you know, you walked by this specific thing 1,000 times, they'd have to prove that you actually knew of the material adverse fact affecting the condition of the property. So that's the 5th prong. Yeah.
How this relates to when you are under contract on a property, you get the inspection report back. Inspection report reveals a lot of material.
Sure.
But then you go, it goes back on the market and.
I get asked this every time I teach this.
No fault to the seller.
Uh-huh.
And there's no mention of anything else. What, I mean, what do you, what?
Because it fell apart because of inspections.
Correct.
That's a good point.
Foundation issues, pests in the house, like.
Yeah.
You have a duty to disclose anything you found from that inspection report.
Got you. So that, because at that point, it's an actual.
Any adverse things,
What if you were the buyer's agent?
or to fix it. Well, as the buyer's agent,
Right, but I'm saying, like, what if you know, you were the buyer's agent?
Right.
Your buyer is the reason why it fell apart.
sure,
And then the listing agent, then,
Puts that up.
right, doesn't disclose anything after the fact.
They supposed to put that inspection up.
yeah.
Inspection.
I mean, so you're saying, what do you do as the buyer's agent? And like, you're saying report them, or
I think that should be done. I mean,
that's probably more of an ethical thing.
Mhm.
That's more of like how do I feel about that? But you also don't know what they're disclosing to the buyers, like, once they go, once the agents are talking, you know.
Like, hey, why did it fall out? And the listing agent
Yeah.
would be like, well, it's got some foundation issues.
Or the inspection, okay, so what happened with the inspection? And at that point,
Right. Tell
like,
me more.
okay, I wanna know. You have a duty to disclose
so
any,
it's only if it does not have to be delivered up front.
You're talking about when they relist it?
Correct.
It needs to be provided at some point, because you know about it. I don't care when it's disclosed, but it needs to be at least the things that you know about, which would be anything negative in that inspection, those need to be provided, whether that's providing the inspection report or whether that, however you want to disclose it. That's a material, let's run through it. It's a material that's relevant, obviously. It's adverse. It's gonna affect these new buyers. It's bad.
Yeah.
It's a fact. You got an independent report from a party right, from a home inspector about the property's physical condition. Well, they're not inspecting the neighbor's property, and you have actual knowledge now.
So then on the flip side of that, as a listing agent,
You should tell your clients to fix it.
you should tell the buyer's agent.
Now, if you fix it, you don't have to disclose anything.
If you feel like it's going to go south,
Yeah.
can I say, I don't want to see the inspection report?
Absolutely.
Because at that point.
Oh,
Listen,
I never even opened.
because then you don't have actual knowledge.
Wait, but
So wait a
you're,
minute.
but when you're the buyer on the buy side, you're sending the inspection to the
Yeah.
listing
Yeah.
agent.
So
Yeah.
I'm
You
there,
you
like I
can't
said,
say
it's gonna be really bad, and my buyer will
Yeah.
back out, there is no chance. in
Okay,
hell
well,
that
yeah,
we're
in
gonna
that
go
case.
forward.
So you're saying if the listing agent.
They're like, you could try, yeah.
Right, okay.
Yeah.
So I consider it like this, just like this, and I'm curious, because it could have gone a bad direction. Because we put our house, it was put back on the market. They did not disclose anything. I asked, is there a reason why it went back on the market? Oh, no, it's just due to the buyer. We put in a contract on it, got an inspection. There was a terrible problem with the roof. I went back and said, my client really doesn't want this. Can we release this now? What's the deal? Like, did you know about this? He's like, I kind of knew about it, but I'm like, so they must have gone.
Well, you have a little bit of leverage there in that scenario.
Legally, he should have told me that up front. And
Yeah.
in fact, he didn't. If we had wanted to fault that.
You could prove that he had actual knowledge. If you-
After the 10 days, we could have still gotten out of that contract, right?
And more, that's not necessarily, that's not necessarily affecting the seller. This is only for the listing agent. The seller has no duty, right? So the seller doesn't have to disclose jack squat. Right? Virginia law is pretty transparent. You guys get your disclosures when you go under contract, right? This is as is, other than, what you find in your, the inspection and everything. But Virginia law protects sellers tremendously. This has nothing, so I don't believe it would affect the contract, but he might be in trouble with the board.
If
The real
the
estate
agent
board.
doesn't disclose it, but it does.
It's an agent duty, it's not a
Has
seller's
the
duty.
Contract.
Sometimes the less you know as a listing agent, the better. Yeah.
This is true.
So it's, oh. So we.
And
need to
that's a
know
good
that.
conversation to have in a listing appointment. Be like, if there's anything that you don't want, like, tell them, I have to disclose any material adverse facts to the buyers. So be careful what you tell me. If you don't want me to disclose it, I literally, yeah, I had an agent. I had an agent in this room come to me with this exact scenario. And I'm not naming names, but I had an agent in this room with this exact scenario, and they say, listen, my client does not want me to disclose this. If I do, they're gonna be upset. But they had already told them about the issue before before they listed it.
Okay.
Correct. And so I said, you just need to have a very transparent communication with this client. Tell them, like, I have to. And they did it and it all worked out, right? If it doesn't, maybe you don't want to do it with that client anyway, right? If they're gonna put you and your career in a bad spot, they clearly don't care anything about you.
Right, I'm gonna say, because the buyer agent is doing their due diligence, they're trying to do this, and then they don't know, and then their clients locked in, and then they find out after the fact, like.
Well, they're not supposed to find out after the
But if they
fact.
do find out, or whatever,
Yeah.
they're locked in, and they can't do anything, right? So they.
Yeah, but you could sue that realtor for a lot of damages.
But the
For any
client-
damages that you might have suffered, that realtor probably is gonna end up being responsible.
So it's really now outside of the deal. It's outside of the
Well, it sounds
contract.
like the inspector did the.
Yes, I would say it's outside the contract, yes. Because this is a real estate, this is an agent's duty, this has nothing to do with the. No, that's a good question. All right, got lots of questions.
So in that, like the situation I mentioned, the buyer's agent calls and says, look, we're gonna have issues.
Uh-huh.
And the listing agent says, don't tell me Just don't send me the report, don't tell me anything. Now, if it goes back on the market, you have to tell the new buyer's agent. I know something's wrong, I just don't know what.
You don't know what it is. What do you have actual knowledge of?
But the contract fell apart because of something.
You could say it fell apart based on inspection, but I have no idea what. They didn't disclose it to me.
That would be advised if you have it as is contract, and they just chose to do an inspection without it being part of the contract, to say, do not send me that.
If they're gonna have that.
So like, because they've done as, it's better not to, as listing agent.
As is, and you don't really need to see the report.
Right, it's better, so you don't have to.
Right.
Yeah, sure.
But so in the.
Unless you want to fix it and just get this thing sold, sometimes that's the better option. It just depends.
Just remember, they can disclose it in supplemental docs and not say anything verbally, and they're disclosing it.
Yeah.
It's your job to check supplemental docs, because one time I was checking a contract for someone, and I checked MLS, and I found it in supplemental docs that they had disclosed a major issue, and I went back to the agent and I said, did your buyer know this? Are they comfortable? They were like, oh, I didn't even see that. So that would be on you.
Yeah, they've met the
Errors and
burden of
omissions.
proof at that point.
Right, so make sure you're always checking supplemental docs.
I was gonna say two things. One, we're assuming that in this situation too, a lot of times as the listing agent, you're like, well, let's just get this over with and fix it or close it, because we're just gonna keep going around.
Correct. Right.
Exactly.
That's the most rational
So it's
response.
like,
Yeah.
But my second one is this did happen to me, and my only option, because Alan knows about this, was to file an ethics complaint against the listing agent. Ended up being the worst possible decision I could have ever made, and I was doing it to make a point, right? But joke's on me, because my clients ended up buying the house anyways, but I just felt like this agent needed to be held responsible. He knew about something, he didn't disclose it. It was underground oil tank, it was a big deal. That was damaged. But because my clients ended up, I don't know what's happening with ethics board, because my client ended up buying the house anyways and got it worked out. They found that nothing was wrong, and now I can't have any of my clients put offers with this listing agent now, I have to refer them, because I'll never, he's never gonna accept. I mean, I took him again through hell, and he won, right? So just be
Wait, you
careful.
want?
Yeah, because my clients ended up buying the house.
Yeah.
And they said, it sounds like everything worked out anyways, but we went through months of ethics in person.
So maybe that's a no.
So why don't they not disclose
After
something?
something.
I'm just saying.
Yeah.
Or doesn't close.
Only hold agents responsible. I just raised it's not your client. I don't know, like, you're doing some permanent damage to yourself, but just by the nature of the way that ethics board works, maybe just let it. And now I have clients that sent me houses that he's a single for, and I said, you know what, maybe it's a great house, but I'm not with it.
All things to consider, right?
Well, and here's the thing, like, here's, I think, our takeaway from this, like,
No ethics complaint should ever be taken lightly, right? Like, that's a heavy decision.
Yeah.
You're affecting someone's career, right? So,
That's huge.
all we can do is control ourselves,
Yeah.
right? Like, that's why you're teaching this class, is because knowledge is power, but applied knowledge is even more powerful. Like, now we know what we're supposed to be doing as listing agents. This is not ammo that, like, this isn't supposed to be ammo in our back pocket. He'll go after a listing agent if they don't do things exactly right. Like, let's get the deal done,
Yeah.
right? If the buyers really want to buy the house, now we're aware of that, right? But does that make sense? Like, I think we just need to look at ourselves
It does.
and then be that change in the market that we want to see and do it the right way. And then before you know it, other people will be like, oh yeah, I did a transaction with Ally and she did disclose it. So wait, I'm supposed to be disclosing it too. Like, hopefully that's what it inspires.
Can I ask one point of clarification?
Yeah.
You said the 4 walls, that,
four corners, like the whole property.
okay, so in situations where water is impacted,
In what way?
it's like the Bay House that I sold that had the Army Corps of Engineers that was doing the dredging. I mean, that's technically not theirs.
That's next door. That was next door. I don't remember that. I don't know.
It was the Davises.
Oh, okay. Was it this transaction?
No, their previous. one.
Okay.
But,
Um,
I mean, do you have?
they were dredging next door?
they were in, okay, so in order to get to the Chesapeake Bay,
Uh-huh,
the Army Corps of Engineer had to dredge the channel,
okay,
which was slated to happen once they received funding
okay,
from the government.
okay.
That funding,
Did they own any part of the channel?
they owned the dock in order to get to the Chesapeake Bay. If you didn't know that piece of information, you would buy that property thinking that you could access the Chesapeake Bay. If you did know that, you would know that if you're buying that property, you're basically landlocked because you have no access.
Yeah, that's my favorite first fact.
Yeah, I would say that's, yeah, I would definitely say that's.
Well, they're in the process of dredging now. We sold it last.
That was potato net?
The buyers know.
It's buyers, well, so
Will you listen?
I was a buyer's agent, it wasn't disclosed, I was the listing agent, we found it out, there's no access, so we did disclose it.
Wow.
But we got congressional funding during the listing. So like it happened, everything got approved while it was under like an active listing. So then we had to go back and like call all the people and say, hey, it's actually.
If it would keep you up at night, it's probably something you should disclose.
Okay.
You know what I mean?
Yeah.
Like, at the end of the day, you can run through all this and it still could be close, right? Then you do the gut check, right? Like, do a gut check. And it's like, is this gonna keep me up at night? Will this, will I feel better if I disclose it, right?
And if roles were reversed.
Yeah.
Well, yeah, 'cause we freaking bought the house, maybe we could get to the.
No, I know, that's what I'm saying.
Yeah, I mean, that seems like
I
a
get
very,
something, John.
yeah.
So I list a lot of houses and a lot of my houses are kind of investor specials.
Sure.
They be like, you know what, just put it on the market. I don't know what's going on with it. We have to stop assuming that it's the listing agent. We don't know what's happening under these bones or what happened prior. So
That's why actual
so-
knowledge is in there.
Exactly. So
Yeah.
why go do ethics complaints? And that's just crazy.
Yeah, you better, yeah,
Stop assuming a listing
yeah.
agent.
If you knew they know though, it's different. I
I'm
get
just
it.
saying, like, we don't know.
That's okay. It's a good topic.
I was like, oh.
This one always brings up good conversation.
When I I was on the buyer's side, I told the agent, you don't wanna see this report, we just need to get out. And she said, no, we don't want you to get out. So somebody before us had gotten out and she provided an
It's like,
inspection
yeah.
and the inspection was perfect. It was fine.
Isn't
So
that
I'm like,
wild?
why is
Yeah.
our inspection so crazy? I look up the first inspector, he wasn't even a licensed inspector.
Oh my God.
So I'm like, you're providing this, like, she was, well, I didn't hire him, it wasn't my, it was the buyers. And I'm like, okay, well, that's garbage. You don't wanna see my report. We went out and she's like, no. He might fix it. And I'm like, so we put every single thing
That's
from
how
the
you do
report
it.
to get fixed, which was like $40,000 worth of stuff. He waited the full like 7 days and then was like, yeah, we want to release you. Finally, right? While we're like trying to look at other houses, like we want, then they went back to market as is. Can they do that? And then she does or doesn't have to disclose because it says is, but should she?
Technically, even if it's as is, I think you still need to disclose it. There's no exception in the statute that says if you really, I don't see that as an exception.
Essentially, as is just saying.
But as is just means like, hey, we know these problems exist, you're gonna buy it anyway. That's up to you,
And then I had some people
but
go,
you still have to disclose it.
Either in writing or call anybody who should.
Yeah.
Yeah.
How do you describe the RPD? How do you explain the RPD, the buyer and seller?
It basically says like the seller doesn't guarantee to get anything about the condition of the property. That provision, Virginia is a very seller friendly state, caveat emptor, buyer beware. I talk about this a lot in another class, but caveat emptor is literally the Latin form saying buyer beware. And that's literally Virginia law's basis for real estate. And so it's saying the seller doesn't guarantee anything, they're not disclosing anything to you. And so that's why I always tell people due diligence is your only time as a buyer where you have the ball in your court, because once you close, good luck. It's
And
your
that's-
problem now.
That's what the sum one, if you read each of those lines, it says, the seller is not making any, warranty about this.
And the
seller is
neighbors,
not-
yeah,
And it just goes down and it's basically saying over and over again,
Seller
they
makes
are
no warranty.
not saying that anything is or isn't.
I tell my clients, if any of those are doing things, that before you go under contract, it's not a reason to get out of it.
Exactly.
Yeah, most of those reasons, yeah. The
Most
only,
of them are not.
everything, yeah, we know what it is.
Inspection.
Right. Change of mind, change of, things like that. People, as much as it might tug on someone's heartstrings, most of those things are not in your contract and they're not a valid reason to get out. And so do your due diligence and don't just enter into a contract without, knowing that, yeah, we want this house barring inspection or, anything tangible that you can prove in inspections, right? That was good conversation. Number 4, transcribe substantive communications. That's just my fancy way of saying put it in writing. Okay, this is just good advice. We have no excuse anymore in this day and age to not put things in writing. A text message counts as in writing, guys. An email counts as in writing. Okay? There is no reason. This isn't the 1990s or 80s where things were a little bit harder to put, like you just had to send it by mail, right? We have no excuse anymore, right? It's one of the best ways to CYA. You follow up on any important or substantive conversations with your client or maybe the other side and put it in writing, and that creates and preserves a record of what was said and when. This comes in handy, especially when a situation turns into potentially a bad conflict between an agent and your client, right? So you follow up, hi, client, this email will confirm the discussion we had a moment ago on the phone about the potential consequences of waiving your home inspection, right? Stuff like that. Just a quick follow-up and do it in the moment, don't wait. Because the longer we wait, we all know we probably won't do it, right? Because that to-do list fills up in your head quick, right? Especially when you got family at home and all the other things. My wife is a checklist girl, right? So that checklist, like, I don't know how she keeps track of it, but she does. But the longer that checklist goes, right, like the less likely we are to do these things. So do it after your discussion, not a few weeks later. Same thing with the other side when you're dealing with another agent, especially if you know they're probably a little bit difficult. Most of what you guys do is on the phone. I get it. But then just follow up, put it in writing. If you know a client is doing something that makes you a little bit uneasy, like waiving something that you would not recommend because they're desperate, put it in writing, right? Just cover yourself.
If you put something in writing, it's like around phone conversation,
Plus, it just looks professional.
but if they don't respond,
That doesn't matter.
it's still. Put.
Yeah, I mean, then the burden of proof would be on them to say they never got it, and good luck with that. Email's pretty, unless you got a rejected email back, you did what you were supposed to do, right? Or a text message, right? It's just so easy to do nowadays. Just follow up any important conversation with that.
Absolutely.
Number 3, be the referral to the source, not the source. Again, not really statute, just good advice. Your value is more and more becoming about the information that you have or can acquire regarding real estate transactions or a specific property, community, or neighborhood. A realtor must weigh their desire and their client's expectation to provide information with the risk of that information getting lost in translation. Perhaps referring a client to the source of information other than being the source is preferable in certain circumstances. It kind of goes with that first point we talked about, right? Nowadays, you guys are like the concierge. Like you are the hub that everything runs, the hub of the wheel. And all the spokes of the transaction run off of you, right? You're lining up inspections. You're talking with the lender. You're talking with the other agent. You are the hub and everything runs through you, right? And there's a lot of power and knowledge in that. But there's also a lot of things that can go wrong because of that, right? And so the more you try to weigh in on things, instead of just letting the people that specialize in their field, like the inspector, like you walk into a house and, obviously if you notice something, you want to bring it to their attention and make sure that the inspector looks at it. But it's another thing to like give you advice on, right? And same thing with, it goes into like being in default or giving advice on a mortgage, right? Like on a loan, right? You're not the professional, you're not licensed in that field. So be very careful of how you do it. Instead, have that referral source that you trust and that makes you look good, right? That's one of the things that I strive for with Vesta. I had lunch with an agent once and I was like, I didn't even get their business, but I was like, what's something your closing company can do that's important to you? And they said, make me look good, right? And it's true, like the better job we do, we're a reflection of you guys. All your vendors are, right? And so when we look good, when we do well, your clients, man, they've just got it all together. Everybody they referred me to was awesome, right? And that looks good on you. And then the roles are reversed and we do a crappy job. Same thing. It's a poor reflection of you, even though you weren't the one doing title, right? You weren't pulling the searches and clearing things, right? And so, so be the referral to the source and have a guy, right? I know a guy, right? Us Italians love to say that, right? I know a guy, but just know a lot of people that you trust and that you can refer instead of having to make the determination yourself.
I
Right.
tell all my clients, if I tell you something and the lender tells you something different. Listen to the lender.
Yeah. Like if a buyer wants to see if a property can be perked for septic, you might have a very strong inclination, but refer them to the county, right? Don't make that determination yourself. The experts, the people that are like, you know, I know it's straightforward, but you'd be surprised at how many times, you know, I see, because again, you've been doing this for the longer you do it, the more you know, right? And that sometimes can be dangerous. So, you guys have heard me say this so many times. This is my most important point. Use the freaking addendums. Like every week, Matt and I will be reviewing a contract and we see either a realtor write in as is, or we see them write in the handwrite a rent back agreement when there's a whole addendum for that. You're just exposing yourself. Nothing good comes of that.
It's easier.
Is it though? I feel like it's harder to write a whole sentence or two than to like attach a paragraph or attach a whole page that's already drafted for me. Your whole contract is just fill in the blank, like, and including the addendum. Yes, use the escalation addendum. It's all done for you, right? Now you guys have less than like other markets, like Northern Virginia's got a freaking addendum for everything. Yeah, if you've ever done any business with an MBAR contract or like a Northern Virginia agent, they'll say. Yeah, Hampton Roads has it too, right? And so.
Saying like DC.
But yeah, these addendums
It's
exist
crazy.
to protect you guys, so that there's less that you have to draft,
Crazy.
right? So use them. Use them. It's just straightforward, but I can't emphasize it enough because I see it every day. And it's just,
I used to do it when I first started. I ain't gonna lie.
there's no need to.
After everything, I was like.
Well, first of all, like writing as is in a contract, that's so vague and really actually means nothing. It means absolutely nothing. The deal's already as is, guys. That's what the disclosure that you were just asking me about. It's literally what that says. Is this is an as is transaction. The only things that's not as is are the things you're agreeing to otherwise in the contract, like inspections. But otherwise, it's as is, because that's what Virginia law says. So use your addendums because it's going to accomplish more of what you're trying to do.
So do you recommend though, with an as is, like if your client is buying, or you're buying an as is, you put in the contract with the as is addendum, is it best to also put it in section 23 just to say this house is being sold as is?
As long as you check it, as long as you
Okay, so
check
you
that
don't really
box.
have to put that in there.
No.
Okay.
If it makes you feel good, put it in,
I
but
didn't know if that was like the place where.
I think some realtors, it just literally makes them feel better about it, like they feel like they did something that they were supposed to do, but it's not accomplishing anything.
This addendum and you attach it, you don't have to put it in.
Yeah, I'll never be mad at you if you say that and with the addendum, but if you're just putting that, hoping to accomplish what you think you're not.
Oh, I got a
You just have
question.
to have it.
Yeah,
It's just one
I hate to be,
related.
I'm just so jaded by this because I see it every day.
Along with that, if the listing agent didn't put in the listing that they want an as-is addendum, do you recommend the buyer includes the as-is addendum anyway, or?
Well,
Go in with
it
that?
protects buyers because there's a provision in there that lets the buyers back out if they're not
So
satisfied.
you do that.
So a lot of listing agents don't want that addendum for that reason.
Exactly.
So do
you know?
you just check the box and say it's included, whether you want it or not, it's there?
But yeah, if I'm on the buyer side, I'm definitely including it.
Okay.
If you're on the listing side and you don't want that specific provision, cross that paragraph out.
Mhm.
It's better than drafting it yourself. You can't get in trouble if you're using addendums. You can't.
Right.
You're using
Question.
addendums.
So I just went under contract and it was an investor property, fully renovated. And they sent it back to me and they were like, I don't want the first closing, I think, to close when the title is satisfied. And then the second one says 10 days after. So how much leniency do my seller, my buyer have?
I don't think I'm following.
So
Go
basically,
on forever, the possession
No,
clause.
Which,
You're talking about.
She know what-
the closing.
so when we, yeah, exactly, so the closing, yes. I don't know the terminology.
you're talking about the closing date?
Yes,
You're talking about where there's two options.
So they
says,
sent it
as
back-
long as everybody's working toward
Yeah.
closing it, and then it says 10 days.
and then it says 10 days.
The other one says 10 days.
Yeah.
Yes.
So can you explain that, like,
Yeah, I mean, basically the top one is like, if there's any contingency that hasn't been satisfied, like, it's a reasonable delay, and it's, they're not in default.
So it's-
Yeah, and so closing could continue. Now, if it's a title
the
issue,
second one?
I think it's kind of implied you have 30 days from there, but
So it's 30 days.
it's
Oh.
implied, it's not,
Okay.
because title says, once you've discovered a title defect, you have 30 days to clear it.
Yep.
So a lot of people kind of assume that, but that's not technically the case. It just says reasonable amount of time. That's very
I
open.
had one with the exact same thing.
Yeah.
The guy swore that he filed bankruptcy at one time, he swore that that mortgage was satisfied. Through the bankruptcy, but it was still a cloud on title, and so we got out of it because we were like.
Yeah.
We're not gonna sit here and wait forever, we're not gonna, they're like, well, just close it. We're like, we're not closing with you.
So he made us check the second one,
So yeah, so then then things are defined and you have 10 days, and then if it doesn't close, they get the back out.
Yeah.
So if you're,
It's already saying we, running behind.
so,
So what'd y'all check? You checked
The second one.
Yeah.
Yeah, they said they're not going
so whoever is the one holding it up, they have 10 days to figure it out from the original closing date.
They say 10 days, I picked the 10 days one, but they want to give you the leniency, right?
Yeah, sure. You can do whatever you want.
Can do it.
Contract out of it. Yeah, as long as both parties agree, you can do it, pretty much anything you want. Doesn't matter, so. I'll wrap this up because I know we're going out of time. Get and stay educated. They're already doing a good job of that, draw it here, right? Laws change. Real estate for those, whoever's been practicing it longer than 10 years is probably different than when you started, right? And laws change in every profession, including yours. That really happened last year, didn't it, guys? Right? The laws changed and, industries change, and the more you're getting and staying educated, you'll never be left behind, but people that think they know it all, and know everything that they have to do, they're gonna get left behind eventually, and they're gonna miss out on something or cause themselves an issue that they're liable for, right? So, it's the same reason why they call it the practice of law. I'm not a master of law, I'm practicing law, because we're practicing daily, like things change and things evolve. And so, your duty is one of ordinary care as a realtor.
Absolutely.
What would if they polled 9 other agents in the area or 10 other agents in the area, would they all do the same thing? Right? So that ordinary care standard is based on, the industry standards and what you're being taught, right? So if you're not staying abreast, you might not be exercising ordinary care, and that's when you're gonna get in trouble and might be subject to malpractice, so. That's it, guys. That's what I have for you guys, but yeah.
About a resource.
Sure.
I get hung up on the clauses. Is there a resource for like the legal clauses that are written out correctly for addendums and things like that? So you're not just like.
Not that I'm aware
pulling
of.
Stuff out of a hat and trying to word it.
Not
correctly.
that I'm aware
I
of.
didn't know that.
I think there's some in there.
I know there's some in MLS, but not.
Like, what are you talking? Give me an example.
Well, like, for example, if you want to state something about the respected.
Sure.
Kind of like, gotta like frame it where it's correct and legal, but how do you do it? Like, is there a set?
No, I think disclosure is most of the battle in your guys' business, right? Like disclosing things you're supposed to disclose is gonna keep you out of trouble and, yeah, I mean, no, I don't have a resource for that, unfortunately, yeah.
Yeah, definitely.
Thanks, did you have your hand raised? Oh, no. Thanks, guys, I appreciate it. Enjoy, there's plenty more chicken, I think, so I'll order for that. Yeah, so we're gonna do this every month. I'm thinking next time, we're gonna go over the types of deeds in Virginia, so less sexy, but it's good for you guys to know, so. But if you ever have any other topic ideas, happy to discuss them, so. Make sure you sign that sign-in sheet.
John,
Thank you, John.
Or?
For what she just said, to kind of easily sign like addendums and,